Chairperson Joe Buscaino. Joining me is Councilmember Curran Price and also Councilmember Gil Cedillo. Today is Wednesday, February 18th. Welcome. If I can direct your attention to the agenda. Colleagues, looking at the agenda, we will take, unless you want to pull an items 1, 5, and 6 on consent. Again, items 1, 5, and 6 pulled on consent. Is it okay with that?
No objection.
Colleagues, okay with that? Okay. You go with that, Neil? Okay, hearing no objection, we will approve items 1, 5, and 6 on consent. That will be the order. Have we secured a room yet? Not yet? We'll take item 3. Okay, we'll take now item 2. Michael, if you can read item 2, please.
Item number 2 is a report from the Bureau of Engineering relative to a vacation on the northwesterly side of Park Drive from Ewing Street to approximately 128 feet northwesterly thereof.
And we held this on the desk. I believe Mr. O'Farrell has an amendment on this item.
Yes, I'm Gary Benjamin from Councilmember O'Farrell's office. So there were several recommendations from the Bureau of Engineering that we sought to modify. Part B in their letter was to deny an additional 10-foot vacation. I've discussed that with Bureau of Engineering, and so we would like that request for the extra 10 feet to be granted. We also had some modifications to conditions 5A and 5B, which are regards to constructing curb and gutter along the side of Park Drive and Ewing Street, as well as I believe it's conditions 10 and 11 regarding installation of street lighting and tree wells and street trees. So we would like to modify and in the case of 10 and 11, eliminate those conditions.
Okay, Mr. Yu, do you have any issues with these amendments?
Yeah, that's correct. Edmund Yu, Bureau of Engineering. We have talked to Council District, and we are fully in agreement that we will go along with their recommendation.
You're okay with that?
Yes.
Okay. Colleagues, any questions on this item? Okay, hearing none. We'll approve item number 2 unanimously and take that over to council. Thank you. So item number 2 approved. Thank you. Okay, item number 3.
Item number 3 is a report from the City Attorney and Ordinance relative to amending sections 61.162, 62.163, and 62.169 of the Los Angeles Municipal Code to allow landscaping, including the planting of edible plant materials within the parkway portion of the street in an area zoned for residential use.
Thank you. We held this item from a couple weeks back. We have, just so that Mr. Jordan can report to the committee, questions we have about any liability concerns on the specific ordinance as it relates to adopting this ordinance.
Okay, Ted Jordan, Assistant City Attorney. Thank you for holding it. I know I was not here at the last meeting. Yep. So what?
On work business.
Yeah. So what? Yes, it was. What was your specific question?
Question is, are there any liability concerns relative to adopting this ordinance?
Not relative to adopting this ordinance. This ordinance will allow the planting in residential neighborhoods without a permit, landscaping in the parkway areas in the public right-of-way. But they have to be consistent with the Public Works Department's residential parkway landscape guidelines.
There are requirements in
There will
place.
be requirements. There are guidelines that have been adopted by the Board of Public Works. They are in the process of being revised.
So you can't plant prickly pears on the sidewalk, whereas a kid can just dive in and get stung.
That's correct. I have Lance Oishi from the Bureau of Street Services. Lance's job will be to help create those guidelines. Those guidelines will take into account the liability issues that I think you're asking about. It will also require certain levels of care and maintenance. So, for example, if there's If there's some type of fruit, you can't just let it sit there and rot. That'll be part of the homeowner or property owner's maintenance guidelines
Very good.
to keep that area clean so that it can be used by the public for the public right-of-way purpose.
Very good. Appreciate that.
These aren't private, this parkway is a public space, right?
Well, this parkway is the frontage of someone's property, so it's typically that area between the curb and the sidewalk. It's part of what we have as our public right-of-way easement, although technically the property is owned by the property owner. We just have our easement across that. So it's that, and it's only that part fronting the property. So if you wanted to plant some type of shrub in front of your neighbor's property, you can't. They would be allowed to do that as long as it's consistent with the guidelines.
Questions?
You can, did you say you can or you can't?
You cannot. You can only do the planting in front of your own property.
Got it.
You good?
I understand.
Now, one thing just to point out, because in the original council action, it also talked about trees.
Fruit trees.
Fruit trees. What you have before you is only for the plants and shrubs. Trees will always require a permit, and trees are subject to a separate tree selection guide. So
Right,
what we're
which this
talking about-
committee approved months ago.
Correct. So what we're talking about here is only the other types of plantings, the shrubs and ground cover.
Right.
And if you wanted to remove a tree in order to plant these kinds of materials, you need to get a permit
To
remove
do
the
that.
tree. So trees are still subject to all of the same permit requirements, albeit we may have a larger number of trees available.
Very good. Okay, appreciate the clarification. We have a motion to approve this item. Mr. Price moves the item, and Mr. Cedillo seconds. And we'll approve item 3 without objection. On item 3, my fault. Sorry, I have one card on item 3. So let's hold off on approval. Barry Johnson.
Hello, my name is Barry Johnson, Studio City stakeholder. I think on this issue, we again have a one-size-does-not-fit-all. And neighborhood characters, there is different neighborhood character in every neighborhood in Los Angeles. And where I live, I don't think I'd look kindly to the parkway next door to me being planted with corn and 6-foot corn stalks, perhaps being in that parkway because it's not with my neighborhood character. I also believe there's safety issues. Right now we have grass or maybe low-lying native plants, which when you're backing out of your driveway, you can see what you're backing into. If these things go too high, you have a safety issue. I think there's also a safety issue if you start planting lots of fruit and nut trees. People are going to be out in the street trying to pick their fruit and nuts. What's the city's liability for those people getting hit when they're out in the street doing that? Again, I think this is something where each neighborhood council area should opt in collaboration with their own council member. I don't see it for my area, and I think there are a lot of areas that would say, if we love that you plant and grow your own food, but you've got room to do it on your own private property, do so there, not on the parkway, which has so many logistical things with people just parking and the passenger getting out of the car, walking across the parkway to the sidewalk. So I really think you're opening a can of worms here that each individual neighborhood council area should decide for itself. Thank you.
Thank you, Mr. Johnson. Okay, seeing no other public comment cards, on this item, we'll motion by Mr. Price, second by Mr. Cedillo, and without objection, we'll approve item 3 and send that to council. Thank you. Okay, item number 4.
Item number 4 is a report from the city attorney and ordinance relative to amending section 56.11, Article 6, Chapter 5 of the Los Angeles Municipal Code to prohibit the storage of personal property in public areas.
Okay, at this point, the request of the city attorneys, what we'll do is head over to closed session. And we do have a room available, Dennis? Right next door. And so we will be in recess during closed session, at which point we'll come back out, hear the item, and then take comment cards. Okay? Do you want to read the disclaimer?
So, so the committee is going to recess to closed session pursuant to Government Code Section 54956.9D1 in order to confer with legal counsel regarding public litigation concerning the storage of personal property on city sidewalks, including the validity of the Los Angeles Municipal Code Section 5611 as referenced above.
Oh, can you also say the case name? It's Levon versus City of Los Angeles. The specific case is Levon versus the City of Los Angeles.
Let's wait for Mr. Cedillo. Now back in open session, and thanks for your patience. And if we can call City Attorney to the table for some questions as it relates to item number 4 before us. Valerie, how are you?
Thank you. Good afternoon, Senior Assistant City Attorney Valerie Flores.
Thank you, Ms. Flores. Please provide an overview of this, of the changes provided in this draft ordinance. And I want to also talk about the primary enforcement agency. Who will that be? Will it be LAPD, Street Services, Bureau of Sanitation?
Okay. This ordinance would make it unlawful to place personal items on a city sidewalk. And then it differentiates between different types of property in terms of how the city would go about removing the property. But first of all, you should know that it prevents someone from putting property within 10 feet of an entrance to a business or a driveway to try to, make egress and ingress easier. If there is unattended property on a city sidewalk, then the city would be able to place a notice on the property, and the notice would state that the property could be removed in as early as 24 hours if it's not removed by the owner. And then if the city goes back and the property is still there, the city can remove it. Now, the notice only applies to what's defined as personal property. So if the city finds items that are not personal property, they can be immediately picked up and destroyed. And that would include bulky items and also hazardous items like flammables, sharps, any sort of human feces or anything else that creates a public health hazard.
So a sofa?
Yes, right.
How about a TV that has rabbit ears, antenna ears on it?
Yes. Furniture and appliances are considered bulky items. Basically, the definition is anything that can't fit in one of the city's trash cans with the lid closed is considered a bulky item, because it's kind of hard to figure out in the universe every sort of bulky item a person might have on the street. But if it's not capable of fitting in a city trash can with the lid closed, then the city can simply pick it up and destroy it.
This would include then the practice that some merchants have of putting their appliances on the curb on the street for sale.
Yes, if the merchants don't have a permit, they would be notified that if they don't immediately remove them, take them off the city sidewalk, that they could be confiscated and destroyed.
So this is an ordinance that both addresses the issues of our shelter-resistant homeless, but also businesses that impact
That are encroaching without
encroaching,
a permit.
right, without a
on
permit.
the city sidewalk.
Very good.
And then to go on with the procedure, after 24 hours, the city could come back to the location, and then the personal items, not the bulky items or anything hazardous, but the personal items, the bedding, the medicine, the papers, those would be picked up, and they would be taken to a warehouse. There would be a note left on the site where the property was taken that would give the owner information about where to go to retrieve the items. And when the person showed up to retrieve the items, they will not need to show ID. They can reclaim the items simply by reference to the location of the items and a specific description of what was picked up.
How much time do they have to do this?
90 days.
And why not have an ID required?
One, a lot of people don't have ID, especially our homeless population. And we want to encourage people to come pick up their belongings. The whole purpose of storing them is to allow people the time to come retrieve them. And some people, might be reluctant to come in and claim their items if they had to show an ID, or they may not have an ID. So for those two reasons.
And as for the storage facilities, I think in order for this to be effective, we need to have adequate storage. Have we identified the locations where we're going to store these items?
We do have some storage available downtown, and I believe we have a couple other storage facilities either in the works or contemplated. So, of course, our ability to pick up things is still going to be limited by our resources, both our space and personnel, which sort of segues into your second question, which was who would enforce this. And the principal enforcement division would be the Bureau of Sanitation, because they have trained experts in how to handle materials that are infectious and otherwise dangerous, including, human fecal material and sharps. They have a hazmat protocol that they follow. So all of this, of course, is dependent on the resources. They have both human resources and also space resources. But if there are sufficient resources, as early as 24 hours after a notice is posted, the city could go and pick up the materials. And again, having the Bureau do it in addition to their expertise being a good reason is it's less intimidating for people who may be down on their luck and homeless to deal with a city agency other than the LAPD. So we want to kind of keep LAPD on the enforcement side and keep Bureau of Sanitation on sort of the cleanup side.
So as of today, is there any procedure in place? Is there a 72-hour hold right now once you
Yes.
tag it?
Yes, currently the protocol is to tag it and pick it up in 72 hours, and then also store it for 90 days. So this would shorten the time, again, dependent on resources to actually get it within 24 hours, but it could at least be picked up as early as 24 hours, which in some cases is, important because a lot of these encampments are blocking sidewalks or, encroachments are blocking sidewalks.
Right, we get a report from a local business and where someone can't come in and out of their business, and so the quicker the better.
Right. For those, that could just be picked up and destroyed immediately, because that's not something stored in a driveway or an access way would not be under the definition of personal property, which we would even need to bag tag and store.
Questions?
So it's in part the location trumps the definition of the property.
If it's blocking egress and ingress, yes. Because again, that creates safety issues in case of a fire or need to use the exit.
I think the city attorney is moving forward in the right direction. As a former senior lead officer, there are times where, officers were handcuffed on being responsive to the community's concerns. I recall having just a number of task force to deal with the shelter-resistant homeless, but at the same time bringing service providers. Not only we address the warrant situation, but during the booking process, we were able to bring in additional resources. For us, it was Harbor Interfaith to provide them with a voucher after they cleared their warrant. This is going to be a useful tool moving forward, and I applaud the city attorney's effort in being responsive to residents and businesses alike as it relates to blocking our sidewalks. So,
I did want to make one correction.
Yes.
If something's blocking an access way, it'll still be bag tagged and stored. It won't be destroyed. It's just that it can be just picked up immediately,
Good.
as opposed to waiting 24 hours and coming back. So
Very good.
there is some protection for people who aren't quite aware of the distinctions between
Got it.
a sidewalk and a sidewalk in front of a property.
Okay. Mr. Price?
Yeah, this is a difficult question. I think the city attorney has done a good job, though, in trying to reach some balance. Certainly, we've got stakeholders on every side who are understandably concerned. Residents are concerned about not being able to pass through. Certainly, homeless individuals have rights, and we want to be respectful of those rights as well. And I think that certainly being mindful of the litigation proposed and potential. I think this achieves the kind of balance that's reasonable and responsible for all parties. And I certainly support it, Mr. Chairman.
Gil, anything?
Well, it's I don't know if it's quite lemonade. I mean, it's a specific response to a specific problem, but it's in the context of a broader problem. It challenges the city to address concerns about housing, sufficient and adequate housing. You said a phrase, housing, shelter-resistant homeless, right? And that's a separate problem, but we can't deny that it's not interrelated to this phenomenon. So we're dealing with one very particular symptom, and doing so and trying to do so in a way that's legal and probably the best policy way, but it does really call out for us then to move with all haste and deal with questions related to shelter-resistant homeless and to the incredible housing crisis that we have, which is the other side of this. So.
And who better to lead that effort than you, Mr. Cedillo, as chairman of the Housing Committee? My question...
Easier than licenses.
No, it is.
Everybody's for homes.
The cleanup protocol, I think, it needs to be more streamlined. And if you look at what was provided to us by the Sanitation Bureau, you have a cleanup request. It has an assessment by sanitation or street services, and then they ask themselves, is it a homeless encampment? If it is a homeless encampment, there's looks like a case number that's completed by sanitation or street services. There's a lot of ands and ors throughout this cleanup process. And then when a cleanup is scheduled, it goes down to Bureau of Public Works approval. Then you have the LA Housing, a homeless shelter authority as well, or other service providers. There's an outreach component, which is fantastic. And then the cleaning is approved. There's a 90-day authorization. If it is approved, then it goes to sanitation or Bureau of Street Services notification. At which point, it's just such a long, drawn-out process to the point where, when we're being responsive to businesses and residents, they completely lose faith in their local government. So I'd like to add an instruction, colleagues, if this is okay with you, to instruct the Board of Public Works to report back in 60 days with recommendations on how to streamline and expedite the removal process of these cleanups that are requested. Okay? With that, we'll take, we have a number of cards on this item. If we can, I'll call three at a time. Bruce Schwartz first, Wesley Walker Jr., and Sean Gregory. Please come up. You'll have 2 minutes to speak. And, sir, you are?
Sean Gray.
Sean, okay, thank you.
Wesley Walker.
Mr. Walker, thank you. And do we have Bruce Schwartz? Come on up, sir, thank you. Okay, we'll start with Mr. Schwartz.
Thank you. I'm Bruce Schwartz. I'm a resident of Pacific Palisades. We just got done with the Palisades homeless count, and we counted 72 encampments in the Palisades, a good majority of them along Pacific Coast Highway in the brush. They cause, it's a big fire hazard, as you guys know, and we're working with the Inspector Novella of the Fire Marshal's Office to come up with signs to post to keep people out of there. But I just wanted to say, since I have 2 minutes, that it's become a health and safety issue in the city of LA, and at what point does the health and safety of the citizens supersede, we all want it, we believe in helping the homeless and the civil rights of the homeless, but it has become a Wild West mentality out there where the homeless people who aren't responsible for their items and don't really there's a major disconnect here, and I just think that somehow, some way, the city is going to have to go back to court and overrule these injunctions and take charge and control of our destiny and how to deal with this issue, instead of always having to worry about satisfying the federal injunction. It's hobbling all city services. It's hobbling the city and to get these things done, and a lot of people feel helpless about it. And I think until it's just a problem that is only going to get worse. So that's basically my comment.
Thank you, sir. Mr. Walker, Wesley Walker.
Yes. Good evening. My name is Wesley Walker, and I'm a member of the Los Angeles Community Action Network. And I'm a veteran as well, and I believe in this country, and I believe this country can solve problems like this without criminalizing and arresting folks for having property that you have no right to say what's personal about this property. You can't come and tell that person this property is not personal. I've been working with Los Angeles Community Action Network for years to protect the civil rights of the homeless residents. Until everyone needs a home, has one. And I stress that because this city has the ability to give every homeless person on the street a home. And you rather criminalize folks before this happens, And I think all of you up here could work toward that. It's not just his problem, it's your problem too.
Right.
And I think that you're going about this in the wrong way. I'm opposed to the ordinance because it does nothing to help people on the street at this moment. And it behooves me why you're going to think that these people on the street don't have their own personal property. You could take their property away, but one day someone may take your property away. You got to think of it this way. You only give them 24 hours to decide what they're going to do. There's no way in the world that a person can carry property around 24 hours a day. It's totally impossible. And I already talked about arresting people. You're just further criminalizing folks.
Thank you.
It's not right.
Thank you, Mr. Wesley. Sean Gregory.
Yes, thank you. And again, my name is Sean Gregory with the Los Angeles Community Action Network. So besides strongly opposing this proposed changes to LAMC 5611 because they violate people's basic right to own property, I'm thinking of how will this be enforced? Will businesses have to bring in their signs and merchandise into their stores? Are upscale restaurants going to have to bring in their tables and chairs and foosball tables and his and her seats lined all along Spring Street? No, obviously, is that answer. And so it seems to me that this is just another tactic to, it seems like, encourage homeless people to kick rocks, so to speak, as opposed to addressing this problem. So I would encourage you to vote no on this ordinance unless it is revised to ensure that homeless people are not the ones targeted by this. And thank you.
Thank you, sir. Our next three speakers, please come up. Jojo Smith, Joseph Thomas, and Becky Dennison. Welcome. And for your name for the record, we'll start with you, sir.
Jojo Smith.
Thank you, Jojo. Okay.
And, you know, we're here today because I'm Jojo Smith with the Los Angeles Community Action Network. You know, we keep coming here all the time because y'all want to change these ordinances to go after homeless people. Why is it, can't y'all just find a solution, get us housing, instead of criminalizing and taking, you know, people have property. We have property. We can't carry it around on us 24/7. We need a place to store it, and the storage places that are there is not enough space for a person to have all their property. You know, today you listen to what the city attorney is talking about is outrageous. I mean, come on. How can we have faith in the system if all it is we're trying to do away with a certain class? Thank you.
Thank you, sir. Joseph Thomas.
Good evening. My name is Joseph Thomas, and I'm a member of the Los Angeles Community Action Network. As of July of last year, I was a homeless veteran, and I've been on the streets for 6 years until that time. Now, when I was homeless, I have been harassed, but we have that great divide which says that across Maine, the people that have money, the businesses, the BID, the people that you cater to, they can put anything out. They can put swings. They can put everything out. We can't get trash cans. We can't get anything on the other side because we've been reclassified by this society here. Ella Can has worked for years to protect the civil rights of homeless residents until everyone in need of a home has one. We are strongly opposed to the proposed changes of 5611 because they violate basic rights to own property. The ordinance is in clear violation with the Constitution of the Levan decision that upholds people's rights to own property. Instead of creating a new ordinance that would lead to all the same legal problems, focused on housing for homeless people, increasing voluntary storage programs, and working with people to keep the sidewalks clear and clean without prohibiting property ownership. And I must put in that the county put that accountability on you because the city wasn't cleaning up anything until we had to force and push that in. Do not move this ordinance forward. Vote no unless there are sufficient portions of proposals removed, especially the fact that property that isn't creating a health hazard and isn't impeding sidewalk traffic can't be moved. Ladies and gentlemen, you can't have it both ways. You can't cater to the BID. You can't reclassify us and say this is all right because these people got money. CCA, BID, come on, knock it off. Thank you.
Thank you so much. Ms. Dennison?
Yes, my name is Becky Dennison. I work with the Los Angeles Community Action Network in downtown and South LA. I'm also a resident of South LA, and there are a lot of housed residents who support the civil rights of homeless people in our neighborhoods. Not the support the homeless people's civil rights, but there is no but. You either believe in civil rights for all or you do not. And this ordinance clearly violates the right to property. Existing law right now allows people to deal with health and safety issues. The current injunction allows the city to deal with health and safety issues, to enforce against people blocking the sidewalk. Captain Oreb was here in the back room. He should have told you that the large majority of people comply every single day. Move their stuff to have the street cleaned. Move their stuff when they're asked. Move their stuff when someone has blocked the the sidewalk. It happens every day. There is enough enforcement. The idea that people would have 24 hours to deal with all of their property, not knowing where the property is going, you ask the question, where are we storing property? The only place right now is downtown LA. If you live in Venice, if you live in the Valley, your stuff is taken and stored in downtown LA, which is practically, for folks with no income or very little income, taking it away for good. There has to be a better solution. You do not need to make this law more strict. Current law absolutely allows for health and safety issues and blocking the sidewalk to be addressed. This just isn't within the general nature of people's right to own property. Levan and many lawsuits before have shown that. The courts will uphold people's property rights, without doubt. So all you're doing is putting the city into more litigation as opposed to putting forward solutions or enforcing current laws to address real health and safety issues. We were just at a different committee last week talking about criminalization in the Venice curfew. We said the same thing. How about some housing solutions? How about more property storage, voluntary storage solutions? We never come and hear those here. We only hear further criminalization. And this is just not right, it is not legal, and it's not just.
Thank you. Ryan Navalis, Mark Shinby, thank you, and Stephen Van Zoo.
Hi, I'm Ryan Navalis from the Midnight Mission. The Midnight Mission has a reputation for its unqualified service to the Skid Row community, and we believe that the city attorney's effort to limit the amount of trash, debris, and bulk items that block our sidewalks is a move in the right direction. This issue has gone beyond acceptable limits, and it now infringes on the health and safety of our community. Many rely on public transportation to get to and from work in downtown. The block on 6th from Wall Street to San Julian is a section that is completely unavailable to foot traffic. You have to walk in the street, and in fact, that first lane of traffic has become a footpath. The buses know that. The traffic knows that. I walk into oncoming traffic to get to Pershing Square to take the red line after work every day. It is time that we allow our sidewalks to be used for the purpose that they were built. We understand that homeless individuals need a place to store their belongings. However, what is occurring now is bordering on hoarding. Hoarding affects both those housed and unhoused. It is not allowed in private homes when it is affecting the health and safety of the persons involved. And for the same reasons, we should not allow it on our city streets. Thank you.
Thank you. Sir?
My name is Mark Shinbane. I'm a second-generation business and property owner whose operations have been located in Central City East for over 50 years. First and most importantly, I want to thank Council Members Bonin and Buscaino for authoring the motion and City Attorney Feuer for taking this issue on. I and my fellow stakeholders greatly appreciate your efforts in finding a way to address this critical citywide issue while respecting the current directive of the court. Needless to say, operating a business within the conditions that exist on the sidewalks of Central City East is an ongoing battle that has become unfortunately worse over the last few years. I've now had a dedicated team of employees to pick up trash, discarded property, and worse, discarded drug paraphernalia and human fecal matter that is found daily around our property. As an operator of a food processing and distribution business, this gives me grave concerns for the health and safety of my customers and employees. Thus, this ordinance is a long overdue step in the right direction of regaining control of our streets and sidewalks. As such, I support the immediate removal of bulky items in addition to supporting a 24-hour notice for removal of items as outlined in the City Attorney's report. However, in order for this ordinance to be effective, active enforcement is imperative. There needs to be a budget for the Bureau of Sanitation to have the resources to respond within the time frame. Unless there is a dedicated unit within the Bureau with a truck and personnel assigned 3 or 4 days a week in high-impact areas such as Skid Row, a 24-hour notice or the directive to remove bulky items without a waiting period is meaningless. Additionally, there's another issue on the Skid Row that's multiplying rapidly and requires the city's enforcement. And there's some photos that were given to you earlier. There are now multiple streets with tents and tarps attached to private property, buildings and fences without permit or permission. There needs to be a modification to the language of 5611 that addresses this practice and allows for the appropriate city agencies to enforce what is clearly a violation of our rights as property owners. Thank you.
Thank you.
Hello there. My name is Stephen Van Zyl. I'm Director of Property Management for SRO Housing, the affordable housing developer that houses the homeless here in Skid Row. Mm-hmm. We've been a stakeholder for 30 years. We currently house 2,000 or more formerly homeless individuals in our 30 buildings. And I'm here to...
Thank you for your service.
No, thank you, sir. I'm here to say that sidewalks are not passable. It affects, so we have residents with all sorts of issues. We have physical disability, mental disability, addiction. We have every imaginable person who's been through Skid Row in our buildings currently. With that, it is a challenge for them to go back to their own home. Now remember, I'm coming at it to say that we have actual people paying actual rent, living in Skid Row, and they not only find it difficult to go back to their own apartment that they're paying for, they have to walk through sidewalks that are no longer usable or passable. They walk through feces, urine. Wheelchairs cannot go through certain areas altogether. We all have to step off the curb, walk in the gutter to go around these folks. We can burden our police force to the point where we get them to enforce whatever laws, but the reality is we still have to walk in the gutter, have to walk through this. We cannot use sidewalks for their original purpose. I also wanted you to know that not only are people putting up their tents, they're sleeping outside of their tents, they're putting all their personal possessions around their tents, and setting up blankets with items to sell for only purposes of hanging out with no apparent, there's a DJ, there's a barbecuer, there's a haircut, I have so much more to say. I wish I had 2 more minutes.
Thank you. Our final 2 speakers, Marie Kennedy and Ruth Sarnoff, please come forward. Good afternoon.
Marie Kennedy.
Miss Kennedy, thank you for being here.
Thank you.
Go ahead.
I chair the board of Venice Community Housing Corporation. We provide low-income housing and housing for homeless. We're currently building some housing for chronically homeless with services. We are opposed to this ordinance. We think it actually violates the Levin injunction, but I'm going to leave that up to the attorneys. I think even more importantly, and I would echo what Becky Dennison said, and I won't repeat that in terms of the sort of legal issues. But I think even more concerning is that the city hasn't offered any alternative that will allow the homeless person to keep her property. This ordinance would apply to every public area in the city, except for rec and parks, and that is covered under another ordinance. There's nowhere in the city of Los Angeles that homeless people will be able to store their property unless it is specifically approved by the city. A balanced approach would require that the city provide legal storage options. It does it in Skid Row to some extent, but only in Skid Row. Everywhere else, it doesn't, and even in Skid Row, the program is totally inadequate. It's already utilized to capacity, so no person who doesn't already have a bin will be able to get in. And even if a person is fortunate enough to have a bin, if he has more property than will fit in the bin, the overflow is still subject to confiscation. Venice Community Housing does, we operate a small free storage program in Venice. The city has provided no storage options except to provide us with a 8 by 25 metal storage container, 26 65-gallon rolling trash bins, which we operate completely voluntarily at our own expense. We pay for the insurance and so forth. And we currently have a list of 100 people. We could have at least 200 people on the list. We can't provide for them.
Thank you for your service, ma'am. Thank you so much. Ms. Sarnoff?
My name is Ruth Sarnoff. I think maintaining extreme poverty and trying to repress the movements and behavior of people is probably costing the city more than you can imagine, far more than it would cost to begin a serious and very quick attention to providing the basic necessities of life. None of the rest of us here in this room live that way. If you didn't have a bathroom and you don't have water and you have to walk for maybe 2, 3, 4 blocks to get water, or maybe a mile, and you can't even move around the city or make use of parks or many of the public facilities because, frankly, you have to carry your belongings with you, or you have to move maybe more than your energy allows. You're also sleeping on the ground where you are absorbing an awful lot of pollutants, and we're destroying the lungs and the health of people who have to do this. I think I remember when there were efforts at a number of times to try to get bathrooms and drinking fountains and things like that in the metro stations, and it's been a no-go. And also now with what was done to the homeless and other people who might need to sit down that don't have a ticket for a rail line or an immediate trip are excluded at Union Station. These are very draconian methods, in my opinion.
Thank you. Okay, that concludes our public comment on this item. We do have 3 cards. It says general comment. So did you fill out the wrong card? What's your name, sir? Ezra. Yeah, it just said general comments. Okay. So please come forward. Ezra Gale?
Yes.
Thank you, sir. Welcome.
Thank you. My name is Ezra Gale with the Central City Association. We're going to keep our comments brief today. We really want to thank the committee for bringing this important item here today. We want to thank the city attorney for their diligent work crafting this ordinance. We believe that this ordinance strikes the right balance, an appropriate balance for the multiple communities, not only here in downtown, but throughout the city. Takes into account the critical health and safety concerns of all Evangelinos, as well as those who come to visit our fair city. And we believe that this is a step in the right direction to ensure that our streets are usable, safe, and ADA compliant. So thank you very much.
Thank you, Ezra. Okay. With that, do we have a motion to approve item number 4? Anyone want to move it? Okay, Mr. Price moves. Mr. Cedillo? You want to chime in?
Yeah, this is obviously a troubling vote for us. It's the status quo is unacceptable. There's some concerns that were raised that were very that we should pay attention to, and there's this question of a right to property, and there's competing interests. So when someone has property that gives them certain rights, it gets competed with other people who have property, and they have their certain rights. And so we're trying to find the balance and reconcile competing rights to property. And so I want to make sure that we do this more than the minimum. More than the minimum, I'm concerned, I would suggest raise this for our city attorney, for our council here. This right to property, this personal property aspect, I think we need to think about to what extent we put limits on that. And so it's just a thought for you guys to consider. I want us to go beyond just meeting the legal minimum, but that